Hello friends, in the series on the income tax cases, today we will discuss a very important case on the condonation of appeals filed by the assessee or by the revenue. The name of the case is Principal Commissioner of Income Tax versus National Fertilizers Limited. This case has been reported in 458 ITR at page number 20. The matter has been decided by Delhi High Court and the date of the judgment is 23rd August 2023. As we see in the income tax litigation that both the revenue and the assessee sometimes delays the filing of the appeals, and in case whether it is assessee or whether it is revenue is not able to satisfactorily explain before the courts the reason, the causes for the delay, then the appeal of the assessee can be rejected only on the ground also that the appeal is delayed. Although courts take very liberal approach while granting the condonation of appeals, but it should not be taken as a right, it should not be taken as granted that the condonation will be allowed by the courts. This is the perfect case to understand this concept. In this case, the revenue has filed the appeal in the Delhi High Court with a delay of 498 days. So, the revenue also filed the condonation application under section 151 of the Civil Procedure Code 1908. When this condonation application went to the Delhi High Court observed that in this case the department is not able to explain the sufficient cause for filing the appeal in time. The court said that in this case the delay is for an inordinate period, that is 498 days, and also remarked that for filing the condonation application the department has used a cyclostyled proforma in which the department has filled in the number of days of delay. Subsequently, the sufficient cause was not explained, and Delhi High Court also said that the department gets 120 days to file the appeal in the High Court. This time is sufficient to file the appeals on time. So in these type of circumstances, when already the time allowed is 120 days for filing the appeals, so in that cases it becomes more responsibility of the department to file the appeals in time. Delhi High Court said that in the present condonation application there is lack of seriousness on the part of the department, there is negligent or deliberate dormancy on the part of the government officials which cannot be countenanced in any case. Friends, the point is that whether it is the appeal of the revenue or whether it is the appeal of the assessee, we should file our appeals on time, because we have already seen that there is a long queue, whether it is in the CIT appeal or whether it is ITAT or High Courts, that the assessee gets its hearing after a long period. So if the assessee files its appeal late, then even the assessee cannot file the applications in the courts that our matter should be heard early, because already the assessee is late. So even the assessee loses its right in those cases, because it will be taken very negatively by the courts. And more importantly, the condonation should not be understood that it is a vested right of the assessee or the condonation will be allowed in all the cases. The simple rule of condonation is that the assessee has to, or the revenue has to, explain each and every day of delay. The delay should be supported by proper evidence, that if for example if the assessee files the appeal late due to ill health, then in those cases proper medical certificate should be attached and the proper reason should be explained and proper sufficient cause should be explained that why the appeal is filed late. Friends, this case is very important as far as to understand the concept of condonation of application filed by the revenue or by the assessees. At the end of this video, once again I am repeating The name of the case is Principal Commissioner of Income Tax versus National Fertilizers Limited, and this case has been reported in 458 ITR at page number 20. The matter has been decided on 23rd August 2023. Thank you, friends.